Good morning and good evening to all of you, whosoever is any part of the world. This is the first class of Administrative Law, Canadian Administrative Law. Before we start with today's class, let me say you something about NCA because I know that few people or many people, whosoever will be listening either on YouTube or on record by way of recording, by way of Facebook, by any means, they will be like new to NCA. That is why I want to brief something about NCA. Then we will shift our focus towards Canadian administrative law, and this class would be purely for Canadian administrative law. As far as this National Committee on Accreditation, whosoever comes from the world gets an accreditation with the National Committee and gets his or her credentials assessed. Then 5 exams are given. Canadian administrative law is one of them. And believe me, all subjects are interrelated. Let us start with foundations of Canadian law, which tells you about the foundations of laws of Canada. Canadian constitutional law tells you about the Canadian Constitution, your charter rights and freedoms. Then comes the Canadian criminal law, which talks about any of the mischiefs, offenses committed in Canada. Canadian criminal law. Then comes the professional responsibility. Being in lawyers in Canada, you need to be professionally responsible. That is what professional responsibility tells us. Now coming to today's topic, that is Canadian administrative law. Canadian administrative law, as the name suggests, let me introduce this subject to you. I will be dealing it in a different manner. My whole endeavor will be to make it very easy, understandable, and appealable to your mind. If I am to put it, people do come to me, students ask me, that is why I'm putting it, that what is the difficult subject? No subject is difficult. No NCA subject is difficult. But still, for their sake, whosoever wants to differentiate between easy and difficult subjects, Canadian administrative law is one of the simplest subject. Easiest. First easiest or second easiest among 5. Why so? I will support my assertion with an argument, and that argument is there are 3 branches of government in a democratic society. In democracy, government, executive, judiciary. Of course, 4th pillar is the media. But still, if you count 3 things, legislative, executive, legislative means to say government, executive, and judiciary. So this part of our study pertains to the administrative actions, the actions done by the executives. Every action which is done by any executive, whether that has been done in correct manner or not, whether that is fair enough or not. That is the sole motive of analyzing this subject. Now, let me start with Canadian administrative law. As the name suggests, administration. Administration is done by the governmental branch that is known as executive. This is not part of the syllabus, but I am trying to put you what is administrative law. And once they are to administer the people, many actions are taken, many decisions are taken. Sometimes some decisions are good for people, some may be bad. Or some may be good for one person, another for maybe bad for another person. But whosoever comes across a bad actions of the executive, then they have a right that he has not been dealt properly. So this is what is administrative law, that whenever you feel you as a person who has been administered, who has been given a decision, whose job has been terminated in any manner, then that person have got certain rights. And those rights, how those rights can be exercised, that is what is administrative law. So let us first understand what NCA is expecting from us. NCA is expecting from us that you should know what is procedural fairness, what is judicial review, what is substantive law. I will come one by one. You can keep on jotting down, writing down. You should keep ready with your pen and paper so that in today's overview class of administrative law, you may jot down the things which will be really helpful in covering the whole administrative law subject. Now, let us go one by one. Whenever a decision is given, whether proper procedure has been followed. Say, whether the second question is, the person who has given that decision, whether he had the right to give that decision. If the decision is not fair, then where to go? Judicial review is the efficacious remedy. Many people do come to me when I'm practicing on the immigration side that we have been given a decision by the immigration authorities. Of course, we are talking about Canada, but no appeal right has been given. Whether their decision becomes final, the answer to a reasonable person may be yes. But to a lawyer, there is always scope for judicial review based on certain things which should not have been done by that officer while giving that immigration decision. That may be for visitor visa, that may be for PR application, that may be for family applications, anything. So judicial review is always available. Judicial review is that efficacious remedy by which any executive action can be challenged. So I have given you just one. You are doing job. Your services have been terminated. Of course, we will be studying how we can have an efficacious remedy for the termination of our job. This is something general understanding of the things that what this subject means to us while we will be in Canada, while we will be in any part of the world dealing with the Canadian authorities, and what we will be seeing towards the authorities as a Canadian barrister and solicitor, meaning thereby Canadian lawyer. Since we all are international lawyers, let us first concentrate upon NCA. So our NCA exam for administrative law can be divided in two parts. One is procedural law, meaning thereby procedure. You will get 50 marks exams out of procedure. If you attend today's class very sincerely, believe me, you can nearly pass the exam, meaning thereby to pass NCA exam, you need 50 marks. So procedure consists of 50 marks, plus minus 5 or 10. say 40 marks exam question is there, you will get easily 35, 38 marks. So very easy to pass. Then comes the second part, which is substantive. That is again 50 marks plus minus. Of course, some part will be aboriginal as well. We will be studying that as well. But if you go by procedural and substantive, you will be able to easily pass the exam. Sometimes, if we include bias into procedure, then it can go up to 60 marks. So only with procedure, you can pass the exams because you need to score only 50 marks. So you can jot down for the very first day that procedure will be plus minus 50 marks, substantive will be plus minus 50. Of course, you need to have understanding of both. Very, very, very simple. If you jot down few lines and act upon those throughout the study of Canadian administrative law, there is no force on the earth that you cannot pass this administrative law in your first attempt. That too very easily. So let us go one by one. First is procedure. As I told you, it is consisting of plus minus 50 marks. Why I called plus minus? 10 marks up, 10 marks down. Same is the case with the substantive. Whenever we are talking about procedure, in one line we are talking about procedural issues. Whether in decision-making process, proper procedure have been followed, whether in decision-making process, proper procedure has been followed or not. That we need to tell the examiner in step-by-step manner. I will read few lines from your syllabus itself, which will enable you to understand in the very first instance that NCA admin law exam is not based on any historical perspective. Many students do come to me who have purchased the book of admin law. They suggest me that this is something very voluminous subject. Say odd 1000 pages are there. I tell them, I came across a study that about 80% of books, means to say 1000 pages of book, 800 pages deal with the historical perspective of administrative law on each step, which is of course 100% irrelevant with NCA exam. So if I am to put it, if you study 1000 pages of any book for NCA exam, out of those 800 pages of admin law are historical perspective by one or the other way. It may be talking about some actions of the executive which happened in the past, say, which are no more relevant. Any concept which is no more relevant for NCA exam is something futile exercise. Some people do argue that we need to have knowledge of the historical perspective, but not for NCA exam. I'm very crystal clear in my approach that if you want to pass NCA exam, you have to have a bird eye approach. If you have a bird eye approach, concepts are very clear to you, then you can apply the facts. You can identify what is required in the given fact pattern. Then you can apply those identified aspects in your answer, which you need to cover step by step. Now, rest are 200 pages. Meaning thereby out of 1000 pages, I have taken the example. Comparative study goes into more than 50 pages in whole of the study. 50 to 70 pages are comparative studies. We will be studying in substantive law, Vavilov case. VA, Vavi, VILOVE, Vavilov case. Now, Dunsmore is no more relevant. Duns earlier, the formula which was given by the Honorable Supreme Court in Dunsmere was being followed by the administrative authorities or by the judicial courts while doing the judicial review. Now, since it is no more relevant, courts are bestowing upon Vavilov case, then thereafter came the Bell case. So that is no more relevant. If I go to your syllabus, page number, what I call it as, just a moment. There it is clearly written. You will find that my assertions, let me go to the physical syllabus. You should also print down the syllabus and read it. Why I am pinpointing? Because today we are doing overview so that by the end, once we complete it, you may not have some doubts in your mind that we have not covered this thing. If this comes, then what we will be doing in the exams? You will, if you go to page number 10 of your syllabus, substantive review material, there it is clearly written that now Dunsmere is no more relevant. You need to go to page number 11, para number 4. At this point, Vavilov takes over, understand it in particular, understand the way in which the majority modifies the process of standard of review selection that had emerged out of the previous leading case of Dunsmere and its progeny. What I am trying to tell you by putting it, I will read once more syllabus to tell you something. That the things which are no more relevant, you are just to have a passing reference of this. So 50 to 70 pages of your studies in the books goes in those irrelevant matter which deals with the comparative study. Now rest are few pages, means to say 100 to odd 135 pages. Out of those, we have made this material very crispy. What is most relevant for NCA exam? What are the most relevant case laws for NCA exams? That too in a step-by-step manner. That is what we are going to teach. When I will be giving you my IRACs, you will be finding that these are less than 40 pages. So by telling you this thing, your job is very small. You just need to have a clear understanding of the concepts. Let us go back where we were. We were understanding procedure plus minus 50, substantive plus minus 50. Then of course, somehow it comes to aboriginal part as 10-15 marks. Generally that never comes, but if at all any question comes, 10 to 15 marks. Of course, I have included bias into the procedure. Bias, if any judicial, if any decision maker is biased, any sort of bias is there, you have to attempt in the exam bias part, then that is covered to best of my mind under procedure. That is why I called it plus minus 60, including bias. So by understanding this overall concept of administrative law, you can very well evaluate that it is something easiest subject. Now let us start with procedure. By the end of the time, I will complete this class because we have spent 20 minutes in overview. By the time I will complete this class, you may be in a position to say that we have covered much part of the administrative law. Of course, we will be dealing every topic individually, that too in detail. Of course, we will be attempting the examination questions as well. We will be reading the examination questions, and of course, those examination questions are going to help us in understanding the concept in proper perspective. Today, your pen and pencil should be there so that you may jot down the things and use it in the coming classes. We call it as chambers. Once you are in chamber number 1, you cannot go to chamber number 2 until you complete the formalities of chamber number 1. Once you complete the formalities of chamber number 1, then you will have to go to chamber number 2. Then you will have to complete the formalities of chamber number 2. Then chamber number 3 and chamber number 4. Meaning thereby step-by-step procedure of procedural fairness. What is procedural fairness? Any procedure which is adopted by any administrative body for reaching at a decision, that is known as procedure. And any democratic setup wants that procedure should be fair enough for every individual. Once the procedure is fair, then it is good decision. If procedure is not fair, then the decision needs to be reviewed or decision is to be set aside. Very simple. Now, I suppose by this time you are in a position to understand in simple terminology that whenever a decision is reached, a procedure is required. Procedure should be fair. That is known as procedural fairness, which is half part of our syllabus. Procedural fairness. One question you will have in an exam, maybe of 50, 40 or 60 marks for procedural fairness. And you must understand what is procedural fairness. If you want to jot down, you can jot down one paragraph, which you can always use in the opening of your question. Once I written my admin law exam way back in 2020, I attempted this paragraph in order to tell to the examiner that I know what is procedural fairness. You can call it as an intro para. This is something cut, copy, paste. You can as it is or amend few words out of it, or you can write it in your own language. But for the purpose of understanding, whenever a decision is reached, it is reached through a procedure. Procedure should be fair for every individual. If the procedure is not fair, then that decision can be set aside. This is known as procedural fairness. Once the question is there, you can jot down procedural fairness concerns the entitlement of rights during the deliberations of a case before an administrative body. Procedural fairness concerns the entitlement of rights during the deliberation of a case before an administrative body. You can, let me say you one thing in between. You can unmute yourself, stop me, make me you to understand the things in proper perspective. I am here to for you to solve your queries. You are free. Just feel free. You can unmute at any point, stop me, and we can thereby revert back. There is no fun of going ahead if we are lagging behind. So let us jot down. Procedural fairness concerns the entitlement of rights during the deliberations of a case before an administrative body. Full stop. These rights flows from two principles of natural justice. These rights flows from two principles of natural justice. First is duty to act fairly. That is the right to be heard. Duty to act fairly, the right to be heard. Audi, altrum, partum. In brackets, you can write down AUDI, Audi, altrum, ALTERAM, partum, PARTEM, bracket close. And second is right to be judged impartially. Right to be judged impartially. In bracket, you can jot down nemo judex in sua casa. NEMO nemo judex JUDEX in IN SUA su CAUSA causa. Bracket close. These rights can be conveyed by the Canadian Charter. These rights can be conveyed by the Canadian Charter. Umbrella legislation. Umbrella legislation. The administrative constituting legislation and the common. The administration constituting legislation and the common. This is something introductory paragraph I have framed. In nutshell, what I am trying to tell you all people is that whenever a decision is to be reached, you need to be heard and the decision should be reached in a fair procedure because every individual in a democratic setup is have a right for procedural fairness. Once this much concept is clear about procedural fairness, in very simple words, I have used the fancy language which I have made you to write. This is something you can call it as intro paragraph. You can elaborate in your own words, but this will tell to the examiner that you know that what is you can call it as what is the gist of the matter, what is the crux of the matter. When giving an opening statement before using the IRAC, some students are new, so I should explain what is IRAC. IRAC, IRAC. I is stands for issue. I is issue. R is rule. A is application. C is conclusion. IRAC. IRAC pattern is issue, rule, application, and conclusion. Whenever you need to attempt the question, you need to follow IRAC pattern. You need to first write down the issue, then you need to write down the rule, then you need to write down the application, which is of course the body of your answer. Then you come to a conclusion. And believe me, I will start with the conclusion, telling you about the conclusion. Conclusion never matters in Canada. Even conclusion never matters in any part of the world. You are a lawyer, I am a lawyer, you have your own opinion, you have your own client standing behind you, you are pleading the case of your own client, you have your own aptitude, you have your own ideas for the same thing. So you may have different opinion. I have my own, but the point in question is, if you are reaching at a conclusion, your whole answer should justify that. You are talking something else in whole of your answer and giving a different conclusion, meaning thereby you are lost. Now, let us go one by one about this formula first. What is IRAC? Issue, rule, application, conclusion. What is issue? The examiner wants to know whether you can identify the issue involved. He has given you a fact pattern. He has given you a question to attempt. You need to write down, giving a head note, issue. Then you have to write down that issue in 1 or 2 lines or maybe few lines. Generally, it is 1 or 2 lines. What is the issue involved? Then comes the rule. Rule you cannot frame. It is always cut, copy, paste. Rule is rule. Rule you have to write as it is. Suppose there is a law, you have to quote that law as it is. That is known as rule. So once you know that what is the rule, which you can easily learn in procedural fairness, step-by-step procedure. So rule you don't have to remember. Issue you have to identify. Rule is cut, copy, paste. You get marks for everything. Issue you write, you get marks. Rule you write, you get marks. It is not that the examiner is going to analyze your whole answer, then giving you marks. No, issue 2 marks, rules 2 marks or 3 marks, 4 marks, 5 marks, depending upon. Because in one answer, you may have to attempt 3 IRACs, 4 IRACs, 2 IRACs. That we will understand. But you must understand that issue you have to identify. Rule is cut, copy, paste. Rule can never be changed. What is the rule? Rule is what is given in the exam. You must not use your intelligentsia or interpretation, because rule may be absurd. Please do remember, rule may be absurd. Whatsoever has been written as a rule in the examination, that is rule, or whatsoever you have learned in your class about the rule, that is rule. You cannot change rule at your own, with your intellect, with your language. 3 things I have discussed. Issue I have discussed you. Rule I have told you. Conclusion I told you. Rest comes the application, where your rear articulation will come into picture. Whether you could able to identify the requisite material from the examination question, then put it at appropriate place. Where to put it? Appropriate place. Sir, from where we will get an appropriate, the whole of the matter? We will provide you. We will tell you that what you need to write in IRACs and what matter you need to identify from the examination and fit it into the DAS material. Of course, that material will consist of case laws, reasoning, and of course, way to the conclusion. Justification of your answer. This is for the purpose of understanding. Once we will be going to issue, rule, application. Application will be the major portion, then the conclusion. Once you attempt it, you will get, say, I told you 50 marks question, 10 marks for first IRAC or 15 marks for first IRAC, then 10 marks or 15 or 20 marks for second IRAC, third IRAC, few marks. So on every step, you will get marks. The moment you overstep, then you are going to lose marks. Of course, there is no negative mark, but examiner is looking for step-by-step process. Sir, what are you discussing? We are not able to understand. I am speaking on your behalf. This is not Manu Jindal speaking. This is somebody from you is speaking. What are you talking of? Sometimes you are talking about procedural fairness. Now you have started talking about IRAC. I'm unable to understand. Now let me say you that thing as well. We are into the first part of our admin law, that is procedural fairness. Now we are understanding how to answer our question. If you know the proper methodology of answering the question, you will be good to pass the exam. Today, we are having an overview. If you don't have the overview in your mind, you are bound to lose marks. You are bound to commit errors. You may not be able to understand what we are doing in the class. That is why people do come to me and tell me that provide us the notes of admin law. I tell them that I have no notes of admin. Then, sir, where we will go, how we will attempt the exam question, from where we will learn. You told us that I will be providing you notes, but first you must understand the concepts, the methodology, the technology, the techniques involved for attempting the exam question. Once you are good with this, you will have sufficient material which I will be providing you. That is my promise to you. But if I provide you in the first instance, you will maybe in trouble. So let us understand step by step. First, let us review what we have learned till time. In last more than half an hour, what we have learned. Procedural fairness, plus minus 50 marks. Substantive law, plus minus 50. Our visa have been refused, no right of appeal, but still we can go for judicial review based on procedural fairness or substantive law. Courts are there to analyze whether some gross error on the aspect of procedural fairness has been committed or not, by the executive giving the decisions to an individual, and every individual have a right for procedural fairness. This much we know. Now we started with procedural fairness. In procedural fairness, I have made you to jot down one opening paragraph, which you can use in your exams. Of course, that paragraph with little, like what do I call it as, with a little more modified flowery language will be available to you in your IRAC notes once I will provide you. What are the IRAC, sir? IRAC is good thing. Issue, rule, application, conclusion. Issue, you need to identify. Rule, cut, copy, paste. Rules you can never make. Rule is given in the exams. No bias, no self-interpretation. Rule is rule. Then application. I will be providing you the material. I will be providing you the arguments. You need to pick up something from the examination question, fix it into the given application material, then write it in the exam in your own language. then come to a conclusion. I told you conclusion never matter. This is known as IRAC. Then we have to go step by step. First IRAC, we will go to chamber number 1, then we will go to chamber number 2, we will go to chamber number 3. Of course, if there will be requirement, we will be going to chamber number 4. So much so, please, please, please do follow me. Once you start following me, you will be good to appear in the exam. Not only appear in the exam, you are good to pass the exam. Sir, your teachings are revolving only around the exams. You are not telling us what is what. I am today giving you an overview. If overview, generally when we were studying, our teachers were used to give us an overview by the end of the syllabus. Oh no, we always thought this might have been given to us in the very first class, then we would have been at ease. We would have been confident in our studies. We would have been in a state of mind which makes us the things easier to understand and without any issues in our mind. Okay. Sir, this happened when you were studying NCA? No, no, no. I did my law in the year 1998 in India, and the same was the procedure adopted by the teachers when we were studying. We used to study for 1 year because ours was the annual system. By the end of our time, teacher used to tell us the overview of the subject. Oh no, then we used to think this should have been told to us in the very first instance. And once I started teaching this NCA subjects, I adopted this methodology. And this is not something made by me. When you go to the court, you should have an opening statement. Once you open up your arguments or open up your case, you give an opening statement to the judge, by which judge may able to understand what case you are going to present before him. Sir, you are taking much of our time in today's class. You are not telling us about admin law. You are going here and there. This is not good. No, no, no. This is good. Because that is not a very big issue. Even if you will understand this overview in very first instance, admin law is very easy. If one has a good overview, after reading for some time, one can appear in the exam and pass the exam. This is based on my experience. Of course, Aditya is going to ask me something. Aditya, go ahead.
Sir, I have a question. Like in a exam question, there are three issues. So for that, we have to frame three IRECs, or in one IREC only we have to frame three issues and answer it.
You have to go in chamber number 1, then in chamber number 2, there will be issue in chamber number 1, there will be issue in chamber number 2, and there will be issue in chamber number 3. So you have to go one by
Okay, sir. Thank you, sir.
one. This is a lapse on my part. Anybody has any question till time? Then we will go ahead. Every question is a good question, and don't ever think that you are wasting time. I always welcome all the questions. Because many a times it happens that when I am to cover many things, I forgot few things. I try not to be, but still, I'm a human being. I can do that error or mistake. So you're always welcome. You can stop me in between, ask me a question. Believe me, every question is a good question. Don't bother your mind, bother me. Don't bother me. I will be welcoming you. So every question is a good question. I always promote asking the questions. Once you start asking, I really feel it good. Why so? Because you are participating in the class. Good. And Aditya and all others, believe me, once we will be studying it, you will be knowing that how to go step by step. So we were doing IRACs. We were about to start procedural fairness. Let us finish one thing by one. I'm giving overview. In examination question. You have to concentrate. You have to read the question well. Why so? You have to read every line. Still, 80 to 90% of the matter given in the examination question will be rubbish, is of no use. I'm giving very bold point to you. That is 80% matter given in the examination will be rubbish, having no values for the purpose of your answer. Even the examiner knows this. But if the examiner knows this thing, why he is doing it? NCA says so. Where, sir? I will tell you. My assertions are supported, if not by NCAs. I have the syllabus. I told you I posted it. I have printed it. I will be telling you, I will be reading. I told you I will be reading twice. So where is that written? I will find out for you. Just a moment. Give me a minute. That is very, very important line. Up to the last minute, people start thinking that sir was saying that matter given 80% is rubbish. Why it is so? Still, sir is saying you should read every line. I will justify my both answers. Now let us go the setting the stage. Uh, Setting the stage is on page number. I have old and new syllabus. That is why I have to go to old one and then I have to come back to new one. Kindly go to page number 4. I will read the whole. Anybody has got the syllabus with it? Printed or in any form? Say maybe in electronic form?
Yes, sir.
Yes, I do too.
Okay. This time, Nicole, you are going to help me. Can you go to page number 4 and setting the stage? Kindly read slowly.
Okay, so setting the stage. One of the most important things to understanding studying administrative law is the big picture. A failure. Yeah.
Big picture. This is not me. This is your syllabus. First chapter of your syllabus is saying you have to understand the big picture. Please read again. Next line.
Yep. A failure to do so may result in candidates becoming lost in extraneous details.
Stop, please. I went to the dictionary. I have poor English. That is why I am telling you in the first class, use dictionary. Sir, when to use dictionary? While studying? No, in the examination. Why so? One word can really distort your whole aptitude for understanding the question. You have a dictionary, spend say 30 seconds, less than 30 seconds to know the meaning of a word which is really bothering you to understand the whole question. Go to the dictionary. I went to the dictionary. I start looking for a failure to do so may result in candidates becoming lost in extraneous details. Extraneous meaning in dictionary is rubbish. I never know. Extraneous is rubbish. Dictionary told me. Now I stood proof. I stands my answer proved that 80% of the matter given in the examination is extraneous, rubbish, useless. You should know the big picture. Then, sir, why you say that we need to read the whole? That too very calmly. Do you know what is that 80%? To know that 80%, you need to figure out the real thing. How you will come to that? Once you will read the examination. You will read the examination question, you will come to know that this para has got nothing for us. Then you won't go again in that para. Or you will highlight that matter. Since you are giving the exams online, I given my exams online, you will have a facility of highlighting the matter, relevant matter, or even you can cross it. Then you will be focusing on that matter alone, which is relevant. Who is saying? I'm not saying. NCA is saying in your syllabus itself. Please go ahead, Nicole.
Yep. So the critical idea at the core of administrative law is this. It is the body of law that governs how people exercising power pursuant to a delegation of power in a statute or occasionally the royal prerogative go about their business. In most cases, the people who have this form of power, again, typically given to them by a statute, are members of the executive branch of government, although often at some arm's length from it.
Stop.
In our yep.
Yes, the point is they are trying to tell you that every power is derived from the statute itself. Any executive who is exercising the power given by the statute, administering you, has got the epitome of power from that statute alone. If you are going beyond the statute, you are losing the marks because you are losing the arena within which you need to work. What is your arena? NCA exam question. If you will be applying your mind in rule, in statute, I told you in the very first instance, kindly keep it in mind. You must not go for a logical reasoning as far as statute is concerned. Whatsoever has been given by way of statute in NCA exam should be true to you. NCA exam question is like a Bible, Gita, Quran, whomsoever you believe, you cannot question it. If you are questioning it, you are putting yourself in trouble because you may not be in a position to understand the whole concept by way of bigger picture. So that is what in this overview we are trying to understand, and believe me, I'm concentrating 100% on your NCA administrative law syllabus. Nicole, kindly complete.
Yeah. So in our system, based on the rule of law, we want to make sure that people with this power exercising it properly. Almost all of administrative law is about deciding what we mean by properly.
Thank you.
Yep.
Thank you. So people are still coming. Good to know. I should admit. Okay, she has joined. She or he has joined. Welcome, who has joined recently. We are in the middle of the class. You can make understanding. Of course, we will be sharing the video, but you can continue from here. Okay. Anyway, thank you very much, Nicole, for helping me to setting the stage. Of course, the further few lines you can read at your own. Why I read it? I told you I will be reading the syllabus twice. Once I read myself, second time Nicole helped me in setting the stage. I am supported by NCA syllabus. Good. Now let us close it. Sometimes study becomes boring, so I do some sort of things to refresh yourself. Please don't sleep in the class. Let us go in chamber number 1. Admin law is very, very, very easy. Sir, you time and again say this thing. Why so? Do you think that we cannot do hard things? Of course you can. Why I'm telling you? Because if you will learn step by step and attempt the examination question step by step, you will get marks step by step. So let us understand it. What it is, now kindly jot down. Now we have done overview. We will be continuing with the overview, but in a different manner. Now, first point, first chamber number one. Kindly jot down chamber number one equal to 10 marks, equal to 5 steps. If you will keep your today's notes handy with you for whole of the procedural fairness question, you will be good to pass the exam. First question, which you need to answer. Of course, we will be doing it in an IRAC manner. I am today giving you an overview. Chamber number one is equal to 10 marks, equal to 5 steps. First step is, first, whether decision maker is an admin body. Whosoever has made the decision, whether that decision maker is an admin body, we will understand. Which is an admin body? There are two types of bodies, public bodies and private bodies. Public bodies, here we will be talking about the decision given by a public body. Second, whether the applicant has a standing. Who has got the standing? A person, you were doing job, you have been terminated from the job. I go for asking procedural fairness. Do I have a standing? Anybody?
Sir, kindly repeat, please.
Whether applicant has a standing, you have been terminated from job. I go to ask for procedural fairness. Do I have a standing? Anybody can answer.
Sir, actually, I'm not getting the question you are asking. Whether you are the person who is who got terminated, or
You,
you are
Aditya,
presenting.
I will put it like this. Aditya got terminated from the job. Manu Jindal is going for asking for procedural fairness, challenging on the basis of procedural fairness, whether Manu Jindal has got any standing.
No, sir.
Okay, done. This one question has been answered. The person who has been directly affected by the decision of the admin body has got the standing. Simple. Whosoever is directly affected has got the standing. Third is, we are to cover 5 points. We are always to cover 5 points. Which code the applicant applies? Which code the applicant applies? It is always a dependent question. We will see once we will study in detail. Which code the applicant applies? Of course, it will be given in your examination question. Fourth is, have any deadline lapsed? Have any deadline lapsed? What is deadline? You all are lawyers in your home jurisdictions. What is deadline?
Sir, it is the duration of taking cognizance.
I'm not clear.
Like, it is the duration between when the crime is committed and when you are going to the court to take cognizance of that crime.
We are not talking about criminal law. We are in the administrative law, dear friend.
Okay, sir.
Simple one word is there. What is deadline?
Limitations.
So nice to hear. Who has spoken?
Manish.
Thank you. Thank you very much for helping me out. Have any deadline lapsed? Meaning thereby whether we have the period of limitation has expired or not. Fifth is whether the applicant has exhausted all other remedies. Whether the applicant has exhausted all other remedies. Sir, what are you talking about? All other remedies have been exhausted. We are here taking an overview, 5 steps. First is whether decision making is admin body, whether applicant has a standing. Okay. Which code the applicant applied? Okay, we know that, sir. Have any deadline lapsed? Okay, sir. No, matter is within the limitation period. Now the question comes whether the applicant has exhausted all other remedies under the admin. Now, sir, it is proper under the admin. I will give you an NCA pattern answer. NCA, when you apply for assessment to the NCA, you may be knowing, or I am informing you, NCA can give you 5 subjects, or NCA can, based on any fact, can say you that you have to do the law in Canada. You are not eligible. Meaning thereby NCA can give its decision. Who is NCA? Admin body. NCA is an admin body, public body, admin body. We will, with this example, we will study the whole. But to understand the 5th point, whether the applicant has exhausted all other remedies under the admin, if anybody is aware about NCA's procedure, say NCA gives 10 exams, you are not satisfied. Another person has been given 5 exams. I have been given 10 exams to qualify for NCA process. This is not good. I want to challenge it. Is there any procedure within the NCA? If anybody knows it. This is something information based question. Sir, what are you looking for?
The right to appeal there.
Right to appeal. Right to appeal is there. There is NCA's internal mechanism which provides you with a right to appeal. Suppose I'm not satisfied. I have been given 10 exams. You have been given, any of you has been given 5 exams. Why I have been given 10 exams? This is not, I have some procedural lapse is there. I'm going to challenge it. First, I have to go to chamber number 1. I have to tell to the examiner whether the decision maker is an admin body, NCA is an admin body, yes. Whether the applicant has a standing, I have been given 10 exams, I have been directly affected. So I have the standing. Now, which court the applicant applies? That is the procedure to be seen over here. Have any deadlines? No. NCA has given me the date, the assessment has been made, 30 days are there. You can apply for review of the decision or appeal. You can go in appeal within NCA's framework within 30 days. I have filed an application challenging that assessment on 25th day. So period of limitation is intact. Now, whether the applicant has exhausted all the remedies, I have gone to the court. The court is bound to ask me, have you exhausted all the remedies? Means to say, once I go to the court, I need to tell to the court, of course, I have exhausted all the remedies available under the admin body. What is the remedy available under the NCA admin body? Right to appeal. There is a committee which will hear my appeal. There is a fees prescribed for that as well. So whether applicant has exhausted, courts are not free. That is why there are internal mechanisms. Before going to the court, before going for the process of judicial review, you have to go to the NCA's appellant authority, which is NCA committee formed to hear the grudges of NCA candidates in appeals. Can I directly go to the court? The answer is no. So generally speaking, in NCA exam, in chamber number 1, answer to all the questions will be in affirmative. Admin body, yes. Applicant has a standing, yes. Which court applies? Yes. We will see what court. Deadline lapse? No. Means answer is in affirmative. Whether the applicant has exhausted all the remedies? Yes. The appeal mechanism was there. We have gone to the appeal. Again, in the appeal, the matter has been adjudged in the same fashion. What it is? It is chamber number 1, 5 steps. We have told to the examiner, we have got 10 marks. If we have done some error, 9 marks, otherwise 10 marks. With this much of the work, you could able to secure 10 marks. Of course, we are going to attempt it. We are going to understand it in a elaborative manner as well. But as far as overview is concerned, in this first class of 1 hour 30 minutes, we have spent few minutes on this 5 steps. By this time, we can memorize it. No need. You have access to your paper. I have written this papers. I always show. It is always better to write in your own language. When I wrote it, once I was studying. Some people do ask me, do you remember? I do remember. But rather than bestowing upon my knowledge, I am bestowing upon this paper because I am allowed to use paper in NCA exams. I can see any paper, I can copy any paper written by myself, I can use any cheat sheet, notes, written notes, printed notes. But of course, I cannot use any electronic gadget in NCA exams. So I'm good to go for NCA exam by this way. Chamber number 1, we have completed. Once you complete all these steps involved in chamber number 1, then you can go in chamber number 2. If you have not, then complete it. So one IRAC is there. One IRAC is chamber number 1. Now second IRAC. Say 15 marks. Marks may vary. Minus plus can be there. This is something tentative idea based on that we are going to attempt 50 marks procedural fairness question. First chamber is okay. We have got 10 marks in our first class. Very simple. Now let us go to second chamber. Equal to second chamber number 2 equal to 10 to 15 marks. Or say 10 to 14 marks. 6 steps. Sir, you forgot what to speak. No. I have not forgotten. Why? Because I am using paper, written knowledge. No need to memorize. You need to understand. Paper is allowed. Why, sir, paper is allowed in NCA exams? Before the judge, even the paper is allowed. You can use any number of papers. You can read from paper. You go before the provincial court, you go before the superior court of justice, you go to before the court of appeal, you go before the Canadian Supreme Court. You can use there, of course, you can use electronic gadgets as well. You can use your laptop, tablet, mobile phone, anything to figure out the things. They are not behind that you should memorize your client's case. They are behind to know what exactly you want to put it. This is what the NCA is looking for. Why, sir, you are repeating time and again? Because in the very first class, I want you make you understand what we need to do with respect to Canadian administrative law. So we were at chamber number 2, 10 to 14 marks, 6 steps. Source. Let us name this chamber as source. Of course, we are going to study in detail. Kindly write down first step. What is the enabling statute? What is the enabling statute? We have to name the statute. Our job is done. Second, what is the subordinate legislation? What is the subordinate legislation? Third is, what are the policies and guidelines of administrative body? What are the policies and guidelines of administrative body? First is statute. Second is subordinate legislation. Third is policies and guidelines of admin body. Sir, there is statute in the exam, but there is no subordinate legislation. Kindly write down. There is no reference of subordinate legislation, but you have to cover up this step. You cannot skip a single step, because the examiner is looking for whether you need to tell only the statute, or you need to tell to the examiner the subordinate legislation as well, and policies and guidelines as well. There is a reference to subordinate legislation, you need to put it. If there is a reference to policies and guidelines of admin body, you need to tell the examiner. Sometimes it becomes tricky. There comes your expertise. There comes your way of telling to the examiner what is statute, what is subordinate legislation, what is policies and guidelines of admin body. Many a times you will find in NCA exam question clearly written. Sometimes it may be confusing, but in both the situation, you need to have the marks. To have the marks, you need to tell the examiner all the things. So 3 steps have had. 3 have left, friends. Fourth is general procedural statute. Once we will read it, this is something cut, copy, paste line, I will tell you. Then fifth is common law entitlement to procedural fairness. Common law entitlement to procedural fairness. What it is little needs elaboration. Once we will be in the class, I am going to tell you in crispy manner. If it's a legislative decision, whether it's an admin decision, we will see. Of course, we will have case references as well. We have flowery language as well. Today we are having an overview. Sixth is Charter of Rights and Bill of Rights. Charter of Rights and Bill of Rights. Somewhere I have written is Charter of Rights came in 1982. Bill of Rights, I don't know. 1960, I suppose. Sir, what is the fun of attending your class? Sometimes you say, do you do not know the things? I need to know. These are also known as procedural triggers. You need to know certain things in the proper perspective. I have told you, sixth step is Charter of Rights and Bill of Rights. It can be called as procedural triggers. Triggers, not written by me, recalled by me. Chamber number 2 is done. We have taken an overview, sir. What it means, we could not follow fourth and fifth, sixth step. We will explain in detail. Of course, it needs elaboration. But we have covered 25 marks approximately. Let us go to chamber number 3. Believe me, in examination, if you will overstep, you are bound to lose marks. You need to tell in a chronological manner the examiner answer of each step. Chamber number 1, 5 steps, 10 marks. Chamber number 2, 6 steps. Easy. 1 IRAC, 2 IRAC. Now come to the third IRAC, which is of course the most important one. Sir, most important one, how many marks you will award it? 10 to 15 only. But little, I will tell you why it is so important. Once we will cover in the class. Five steps. By the time you will complete it, you will see that admin law is more of a mathematical sort of thing. Identify the things, put it into it. This is something formula based. You know the formula, you know the answer, good to attempt the exam, easy to pass the exam. Where we are, chamber number 3. Equal to ten to 15 marks, equal to 5 steps. Okay, good. Room number 1, 5 steps. Room number 2, 6 steps. Room number 3, 5 steps. 5 plus 5 plus 6, 16 steps. Friends, you have access to papers. That is why I do not remember. I may be remembering, but I do not force you to remember. People used to tell me that teacher remember by heart everything, but I do not. Why so? There is no requirement. That is my humble suggestion to you as well. Do not waste your time on those things which are not required. Concentrate on those things which are required. Concentrate upon understanding the things. I know I have not explained you step number 4, 5, and 6 in the chamber number 2. In chamber number 3, I have just started. First chamber was, we need to identify. Identification. Second was source. First was identification. Second was source. Third, these are not written in books. These are my own created things. First is chamber number 1. We can call it as identification chamber. Identify the things. Second is source. Chamber number 2 can be named as source. Chamber number 3 can be named as how much procedural fairness is required. How much procedural fairness? You will many times read as PF, procedural fairness, PF. Abbreviation used in these days is PF. How much PF is required? What we were studying? We were studying plus minus 50 marks, procedural fairness. We have studied chamber number 1, chamber number 2. Now, how much? What is this question? Procedural fairness is procedural fairness. Let us go for 5 steps, then you will understand that how much procedural fairness is required. How much procedural fairness is required. In simple words, you can say that whether procedural fairness is required. Whether procedural fairness is required. I don't know. We have to see. Kindly write down before I tell you 5 steps. This is something why I told you very important, because this is something soul of the procedural fairness. Soul. SOUL, soul of procedural fairness. Without it, we cannot say that how much procedural fairness was required and how much was done. In this, we will read Baker's 5 steps. Baker, Baker, B-A-K-E-R. It is the name of case in which Honorable Supreme Court has given 5 steps. Now, we are not talking about those 5 steps given in the first instance. We are talking about Baker's 5 steps and Knight's, K-N-I-G-T-S, Knight's 3-prong test. Knight's 3-prong test. Baker's 5 steps, Knight's 3-prong test. What is Knight's, sir? Again, this is the name of a case law. We will study it. Of course, we need to know the synthesis of that. Intermixtion of the two. In Baker's case, Supreme Court has given 5 steps, 5 things. In Knight's 3-prong test, the Honorable Supreme Court has given another 3 steps, or say 3-prong test. We have to present synthesis of Baker's and Knight's 3-prong test. Baker's 5 steps, Knight's 3-prong test synthesis. We need to tell here it is the gray area where generally students makes an error and annoy the examiner. But believe me, this is very easy. I will make it everybody's cup of tea. What we were doing, chamber number 3, 10 to 15 marks, 5 steps. How much procedural fairness is required? We were at Baker's 5 steps. Knight's 3-prong test, or their synthesis. Before I will complete this chamber number 3. I will tell you what are the 5 steps which are required. One is nature of decision of admin body. Nature of decision of admin body. What we need to analyze in this room, how much procedural fairness is required. First is nature of decision of admin body, nature of decision. Second is nature of statutory scheme of the admin body. Nature of statutory scheme of the admin body. You can write it as nature of decision, nature of statutory scheme. Third is importance of decision to an individual. Importance of decision to an individual. Fourth is legitimate expectation. Legitimate expectation. Fifth is choice of procedure. I will tell you each step one by one. I will give you key points to judge it in the examination. But do keep it in mind, these are very simple. Don't ever get afraid by some odd comments which I usually hear in the market, that it is hard to understand Baker's and Knight's synthesis of three-prong test. If you will jot down few points, when of course we will be taking it in detail in the days to come, you will be coming to know. First step is nature of decision of the admin body. Second is nature of statutory scheme of admin body. Third is importance of decision to an individual. Fourth is legitimate expectation. Fifth, choice of procedure. Every step is very interesting to me, at least, particularly the fourth one, legitimate expectations. I will tell you this legitimate expectations today itself. Very simple. I put an insertion into WhatsApp groups that I will be giving first class without taking any charges to everyone whosoever will join my class at a particular time on a particular day. You are an aspirant of NCA exams. You want to attempt NCA exams. You have read that advertisement. You have read that brochure, read that pamphlet. What is your legitimate expectation? That I will be holding class as per the Indian time, 7:30 p.m. on this date. That is your legitimate expectation. Do you have any relationship with me? The answer is no. I may be a teacher, but I am not your teacher up to that time. I have put an insertion, I have put an advertisement into the WhatsApp groups or Facebook or any of the social media or print media, anywhere. You are an NCA aspirant, you have read that advertisement. You have made available yourself at 7:30 as per the Indian time PM that I will attend Manu Jindal Barrister and Solicitors Administrative Law class on this day at 7:30 p.m. Indian time. But he never comes forward to hold that class and never informs anyone. But you had an expectations that he will hold the class and tell us about the administrative law. That is your legitimate expectation. Even if you have no relationship with of student teacher or anything. This is something, one example. This is known as legitimate expectation. We will try to understand it once we go into it. So how much simple this is. Legitimate expectations. There are two types. Of course, I do not want to go into that because that will become lengthy. You need to go step by step. Last is the choice of procedure. We will go step by step. Then comes the room number. Rest of the marks are given whatsoever have been left out. 10 marks for room number 4, or room number 4 is the main room, right to a fair hearing. Whenever any room comes, sir, there was no room. We were talking about chamber. We are in chamber number 4. There can be many words which can be used: chamber, room. Some persons goes for say like closed circuit. Certain persons use it as, why? This is for the purpose of understanding that you need to make compartmentalization in your brain. Once you do compartmentalization in your brain as well as in your papers, then 4 IRECs you come across except bias. People say, sir, is it not very lengthy? No, it's not. If you go step by step, it's not lengthy. You will cover the whole paper very easily. But if you will be bothering yourself to go here and there, then you will be, of course, in that trouble. So, right to a fair hearing is the rule. Right to a fair hearing. Room, chamber, arena. Some persons do call it as arena. Let us call it as, stick to ours, because I will be using for times to come as chamber. Chamber number 4 equal to 10 marks equal to right to fair hearing. How many steps? 1 step. You need to identify what is the issue. There can be many issues, right? No hearing has been given. Generally, there will be no hearing which has been given. Decision has been reached. Notice have been served. There will be notice issue. There will be delay issue, discovery issue, hearing. There will be many. 10 to 12 issues can be there where 1 step will be involved. I will call it as 1 step. Room number 4 equal to right to fair hearing equal to 1 step. If you attempt in this manner, you can complete your procedural fairness. So today was the opening class. Next class, we will be approximately covering more than half of the part. And of course, I request to all of you, by the next class, whosoever will enroll for my regular classes, certain people have already enrolled. Kindly do read questions which I have given in this group. So we are on the verge of the end of the class for today. Before I end up the class, I have to say you something. But before that, let me ask you if you have any questions.
Yes, sir.
Please.
Sir, in chamber number 2, in second IREC, in second step, you said that there is no subordinate legislation. So kindly make a clear view of that. I was not able to hear what you were saying.
Yeah, I told you second step is about subordinate legislation. There can be or cannot be subordinate legislation. I
Okay,
do
sir.
not remember what exactly the words I have used, but first is the enabling statute. There can be subordinate legislation. Suppose the Constitution has given us the powers to make the legislation, then Constitution can be the enabling statute. Subordinate legislation can be anything.
Okay, sir.
But that will be given in NCA exam question. We will be able to attempt that what is the enabling statute. If there is no subordinate legislation, the reference of no subordinate legislation given in the NCA exams, then we will write it like this. There is no mention of subordinate legislation.
Okay, sir. Thank you, sir.
Any other question, please? Okay, thank you very much for attending the class. Before I conclude this class, let me say you this was the first class, which is of course without taking any money from you. You are most welcome. People have already enrolled. You can contact me personally on WhatsApp. I will be there to serve you. And believe me, this class is going to be very good for you people or for your friends. And you can directly contact me. Next class, we will be having those students who will be getting enrolled with me. What I will be doing is that I will make you pass by teaching in a good manner. Otherwise, if anybody is expecting any sort of mischiefs, I am not the right person to be contacted. And last but not the least, let me say you very thing, if you read sincerely, it will not only be beneficial for you for NCA exams, it will be beneficial for you for days to come, because I have seen many barristers and solicitors who have not read well in NCA exams are struggling to read it again once they start their own practice in Canada. But if you are good, even up to the uh, even up to the highest court, that is Supreme Court of Canada, this administrative law subject is going to help you for all times to come. Every subject, but in particular, administrative law is going to help you, because daily you will be coming across arbitrary decisions of the public authorities given against the individuals, and those individuals will be contacting you for the redressal of their grievances against those arbitrary officers of the government or arbitrary decision makers of the government. So believe me, this is going to help you in your day-to-day practice as well. So do attend today's classes. Will be really useful to you or not, that you can analyze at your own. But let me say you, this subject is really very helpful for all of you in the days to come. So if anybody has any doubts or any questions before I end up today's class, I'm really thankful that you have given me your valuable time on your weekend. And I'm really indebted to you that you have been very patient to hear me properly, and you have been very calm to make this class happen. And I'm really very thankful to all of you. You can ask any question before we end up today's class. Anyway, I'm good to see all of you and the people who will be coming across me during their individual conversations, and I will be happy to serve you. And thank you very much.
Thank you, sir. Thank you.
Thank you very much, please.